Happy Sabbath, everyone. I would like to start with a word of prayer, if you will join me. Dear God, we want to thank you for this Sabbath that you gave us and privilege of being able to meet here together to study and to share our thoughts and ideas about the times in which we are living. We pray that you would be with us and that you would guide these discussions so that we can benefit from it. Pray these things in Jesus' name. Amen. Okay, so I want to share my screen first. And let me know if you're able to see the screen properly.
Yes, we can see that. Yeah.
Okay, perfect. Okay, so I want to share some thoughts and trigger some discussions around the topic of leadership. Give me just 1 second. Wait, so I'm getting instructions to swipe my video out of the screen. Oh yeah, there we go. Okay, so yeah, I wanted to share some thoughts and encourage discussion about the topic of the change of leadership in particular as we see them in the reform lines, and what the impacts or what the meaning of that is for us. I have observed that we tend, or we can have different opinions to that of what we would have considered usually the true stream externally on a few issues that I would like to discuss as well. And I wanted to understand how that works and how the reform lines speak about that. So if we look at the reform lines, I want to ask, I've drawn here the reform line of Christ and put it on top of our 144,000 line. So based on the assumption that we understand those waymarks and how they work, we mark a change of leadership in 2014. And I want to do this. So we mark a change of leadership in 2014 between John and Christ, so the first angel and the second angel. And we apply that, or so I'm going to assume that we agree on these things and that we generally make the application that John as the first angel is transition it's his authority to Christ, and now Christ is the leadership of the movement, and we've made the application of the transition from Elder Jeff to Elder Perminder, and then we apply that down here in the line of the Levites as well, since this is the middle waymark 2014. We carry that over to the middle waymark of the Levites, where we also see a change of leadership from the SDA movement, from the SDA, leadership to the movement. And then at Pentecost, and I believe this is something we've touched in our recent presentations with Curtis as well, that the movement now takes the leadership and the transition of leadership between the world, or I think we've used the symbols of AOC and Michael Moore, transition to the movement. So I'm wanted to take that as these structures as the basic assumption of these studies, and want to ask if someone has any questions about that, or perhaps disagrees with that application. Maybe we can speak now. Or any inputs or additions to that.
Hi, Andres.
Hi,
It's Charity.
Charity.
I just wanted to understand something. So, when we're speaking about change of leadership within the Seventh-day Adventist, I don't know if it's the Seventh-day Adventist, but there's a point where we speak about the leadership being passed by when we begin the reform line, and we see that God is no longer working with the Adventist leadership from 1989. And we identify that God is now working with the movement. Is that in any way related to what you're talking about with 2019? How does that work when we are looking at 2019 with the SDA and the movement? Because these are people within the Adventist church, and I assumed that people would have to recognize that God gives them time, of course, to recognize that God is no longer working with the leadership in the SDA church. So I'm trying to understand how that can be reconciled.
Mm-hmm. Yeah, I understand the question. I think it's a profound question. Do you have any thoughts on how to reconcile that?
No, actually, I'm trying to understand how we can conceptualize what we are identifying in 2019.
Okay.
With the Levites.
Yeah, so my understanding is that, so if we look, for example, at the line of Christ, 2019 with the Levites would line up with the waymark of the cross. And I understand these transitions of leadership as occurring in a progressive fashion. So, for example, in the time of Christ, even though the leadership or the Sanhedrin was passed by and the message of the first advent of Christ was given to other people, because the leadership was not ready to receive it. It is at the cross that the veil of the temple is broken, and God officially no longer works through the Sanhedrin. So it's, in a way, as you were saying, it is passed by in 1989, but people don't see that officially or formally until it, or should see it until it happens at the cross. So I think I see it the same way in the history of the church. So in 1989, there's LGF, or this movement that receives the message of the second coming of the Sunday law, and it's the Adventist church is passed by, but it's not up to a point where we are ready we're more mature that it's officially in God's eyes according to the line. I don't know exactly what that means in 2019, but if we bring the characteristics of the cross, it would indicate that it's at this point that in the eyes of God, God's no longer working through the SDA church anymore. I don't know if that makes sense.
Yeah, it brings a whole lot more questions for me. So we understand the cross to be a shut door, right? If it's a shut door for who? For the priest, and it's the midway mark for the Levites. So would we mark in the time of Christ? No, that's different. 34 AD would be a different waymark, is it?
34 AD is here. It would be the Sunday low, or if I didn't put the year, like if you want to.
Okay. No, that's fine. You can continue. I think I'm just trying to reconcile that in my head.
Yeah. I mean, I think it's a profound question. It's not that straightforward. So yeah.
Andres, Curtis has his hand up.
Oh, I don't know why I don't see the hands, but yeah, thank you for letting me know. If I missed that, just let me know again. Yeah, Curtis, you go ahead.
Just to the question that Charity had asked, when I think about these groups, priests, Levites, and Ethnims, what I understand about them is that each separate group is a story about the development of that group that will eventually be harvested into God's kingdom based on their geography, i.e., where they are. And I think that story about these three different groups and their geography is separate to a story that's talking about organizations. So if we think of the Jewish church as an organization, and that story of God looking for someone to be their messenger, their messenger, and God flying over the Jewish leaders and then finding someone else to be the herald of that message. In my mind, at least, I think that's different to the story that's being told about priests, Levites, and Ethnims. So when it talks about a transition from John to Christ, it's talking about a transition from a messenger that's getting ready to give a latter rain and then a harvest into God's kingdom. And then again from, let's use the Nethinims, we say it's the stones that plow them and then give them the early rain, whatever we want to say those stones are. And then this movement is going to do that, should do that work of harvesting, etc. So when we get to Levites, I don't know what we would say as being the first. That's giving them a message, that's preparing them to be harvested by us. So yeah, all I wanted to say is that I think the story of the organization is different to the story that's being told by these three groups. So when the leadership is passed by, if you're on a place in 1989 or 2001, I think that's different to what you're demonstrating here in this change of leadership. They're two different models.
Got it. So would it be fair to summarize it in that one model is about organization and the other model is about preparing a people for a harvest or for the latter rain? Or it's more about the messages itself, the message itself?
Yeah, I think you can think of it that way.
Okay, so yeah, so that's one point, and then
Andres, Blessing, and Charity have the hand up as well. No.
go ahead, Blessing and Charity.
Sorry.
Or
I'm
Charity.
sorry. I'm sorry to keep you on
No,
this
absolutely.
point, but I
It's
just
the interview.
so I, I'm trying to understand what Curtis is saying, but at the same time, I'm thinking when we're speaking about the Levites, because I think from these three different groups, when we speak about them, it's a what can we say? it's a group of people, right? And when you have the Levites beginning their line in 2001, when if they're supposed to be hearing a message, are they receiving their message from the SDA organization or from another entity? Because if they're receiving it from another entity, then like how then do we explain that change of leadership, if you understand what I'm saying?
Yeah, I mean, I think, and
Yeah.
correct me if if it doesn't help, but I think what might help is understanding that, for example, here, even though I put SDA church, or maybe let's do it with a word that it might be easier. We know that within the I'll call it the institution of the world, there's two streams, and when we are talking about the change of leadership, it's not from the institution to the movement, it's from the true source of information, which I'm going to put just AOC or more as a symbol, to the movement. It's not from the whole world as an institution. If does that help?
Yeah, I understand that one, because when we begin the line of the Nethinims in 2014, they're being plowed by external events, right? And there's obviously different entities or people that are teaching the message of God. There's external prophets that they're receiving the message from. But when we get to 2021, those external prophets have not progressed enough for them to keep listening to them. So they need to now listen to the movement, because they can no longer get the information from those external prophets. So I'm trying to understand that as well with the Levites, that when we are starting the line of the Levites in 2001, where are they receiving their information from? And if they're receiving it, are they receiving it from the SDA organization? Is there a stream from the Adventist organization or Adventist world where they're receiving the truth from, that it requires for them to make a change in 2019 to the movement? Or they are supposed to just receive the truth from the same entities that the Nethinims are receiving the truth from, because they're also being plowed from 2001. So that's where my dilemma is as well.
Mm-hmm. I think the answer I would initially tend or tie into is that there will be two streams within the SDA church, and the liberal stream, so one liberal and one conservative. That the liberal would be the one that's plowing them together with, of course, the streams of the world. I don't know, like, yeah, the intricacies of that, but I would say that it's one of the streams. So the change of leadership would indicate that, okay, the liberal branch of Adventism, whoever those people are no longer fit for purpose, if they ever were, but they did have a purpose, or they did serve a purpose, and then it has to change, or the movement is where the truth can come from only, or is the only thing that would prepare you for the events. I don't know if that makes sense, or if you agree or disagree.
Well, I hear what you say. I don't know about the two streams within Adventism. I'm not sure.
Okay.
Because for I don't know, I guess for me, what I thought is that when you have the leadership passed by in the SDA church, and I think I remember auditors also identifying within the Adventist church that, okay, you have the leadership being passed by in 1989, so there's no light that's coming from there. But she also identifies when she speaks about water, vite, and all, and she identifies how even those streams of information as well, they cannot be listened to. Basically, those that are against leadership. I don't know. And for me, I thought that when we are starting the line of the Levites, whoever the Levites are, they are supposed to identify the external events correctly and understand they are being plowed by the same messages that not necessarily the same message because they start on different lines, but the external events that are occurring are what they are looking at and they're supposed to listen to. And there's no message that they can get from the SDA church. So yeah, I guess it will always be a puzzle for me, the change of leadership.
I hear you. Yeah, I'm not 100% sure how to approach that, but I mean I hear what you're saying. But the good thing is that I wanted to focus more on the change of leadership from the world. So
Okay, that's fine. You can continue then. I guess it can be a study for another time.
yeah. So yeah, basically I wanted to think about this because when considering a few topics, I mean, I've noticed that particularly in conversations at camp meetings, that our position, not like as a movement necessarily, but a true position, or an accurate worldview that's needed, it does differ from the what we would consider the left wing or the true source of information on the Nethinim's line. And based on these lines, it seems to me that it is expected that we would have different opinions, because if they had the correct opinion on things, then there would be no change of leadership. They would be fit for purpose. And to me, the funny thing is that in a lot of cases, we come to the same conclusion. In some of them, we don't. But even if we come to the same conclusions, as I'm starting to look at those issues, I see that the principles or the ways in that we approach the issues are different. And I think to me that's important, because if we need to sign up for God's kingdom, the kingdom is made of principles, and so if we sign up to a kingdom, but we don't like the way that, or the principles that, got us to a conclusion, or we don't agree with them, even if we got to the same conclusion, we wouldn't necessarily like or sign up for God's kingdom or God's principles. So the last time I presented, we talked about the issue of gun rights and how we came to a conclusion about it from methodology. If you recall, that was different, or it was not necessarily the same as the left wing's perspective about that. I didn't mean to do a review of that study, but just to mention it as one topic that I am seeing that we are not having exactly the same position, or not having at all the same position as the world. So I just want to note that. And I want to ask if someone else, or if someone has another topic that they think we should or we are coming, aside from the issue that, you know, within the movement, we might not have consensus upon a lot of issues, but that we are, or we should lean towards a position that's different from that of the left wing. I'm going to call it like that. So I'm going to say that gun rights or self-defense seems to be something that we are looking at it different than the left wing, to me, whether in its conclusion or in the approach that we take. Does anyone have another topic that they see something similar? Or
Andre, sorry, could you
Yeah.
recap? I know you don't want to go over the study again, but I'm not sure what's the difference, what you're actually saying we're saying about that, and what the left wing are saying about that that's different.
yeah, so maybe I can ask someone to, does anybody remember a bit of that study, or has any opinion or remembers about this study of the 14th Amendment? No one?
So this is Curtis. So what came to mind was, I think you demonstrated that the 14th Amendment, and based on just the nature of self-defense, we as humans have the right to defend ourselves. So in America, for Americans, where it's legal, that right to self-defense extends to the right to bear arms, as the outgrowth of that principle to defend yourself. And just using that train of thought, I think what you're trying to demonstrate is that as a broad brushstroke, we'll just say the left in America will say, no, you don't have the right to bear, or you shouldn't have the right to bear arms. I think what you're trying to demonstrate is we come to different conclusions to the left, in inverted commas, where they say no guns, and we would say yes, guns, to defend yourself at a simple level.
Yeah, it's that what I meant. And the approach that we took, if you remember, was as Curtis was saying, comparing if it applies, if we agree that the state or the militia, or the state has the right to protect itself, then that by comparison and contrast should extend to individuals as well. And so we came to that conclusion that Curtis was saying, and we look at the left wing and they have a different position on that. I don't know if that makes sense, Emma, or if it answers.
Thank you. That's good. Yeah.
So any other points that anyone can think where we differ from the broad term, the left wing?
I'm just thinking with that example there, we come to a different conclusion to the left wing, don't we? And you're saying, I think your original premise was we come to the same conclusion using a different route.
Yeah, so I meant to say that in some instances we come to the same conclusion and we approach it differently, and in some instances we come to different conclusions.
So in this instance, we're probably on the same page as the right wing. Is that what you're saying?
Yeah, on the conclusion, we are on the same page as the right wing.
Yeah.
So I'm looking for examples of either case, whether we come to the same conclusion, but it's a different approach, or we come to different conclusions. straight away. So I have a few examples that I have the tendency to think that we should look at it differently. One of them that I want, so the main one that I wanted to investigate and that I've been reading about is is Trump versus USA. So if nobody else has another example, I want to move into going through that case trial and starting to analyze what the opinions are and what the history was, so that to see if we can come to a conclusion of ourselves. Does anyone have or want to add any other example before we move into that?
I think I remember something to do with how I'm not sure if it's the left or it's the academics, so how they look at history and homosexuality and how they identify basically homosexual relations beginning far back in the ancient Christian history, ancient Roman history. And then we as a movement identify that that's not true. And what was going on in that time is not the same as what we are identifying today as basically same-sex relationships. Because back in the day, you had the issue of certain men or people wanting to show dominance on the weaker or younger people, and then most of the left wing, they basically use that as evidence of same-sex relationships beginning or being seen in that history.
Okay, so I'm gonna add that one. What title would you think we can give to that one?
I don't know, same-sex relations in ancient history? I don't know.
The
Or
history.
beginnings in ancient civilization, basically.
Yeah. Particularly in ancient Greece.
And Rome.
Okay. Cool. So if anyone else has another example later on, we can come back to that. Okay, so yeah, basically I want to start going through the history of this trial, what's remaining of this Sabbath morning study, and then in my next time that I present, I want to conclude it. So yeah, Trump versus USA. I'd like to ask, does anyone know or remember what the context of that case trial was about? What is Trump versus USA?
Correct me if I'm wrong, was that the case that led to the conviction on May 30th, or no?
Yes. So I'm particularly, so it's the one
Not May
case.
30th, sorry, July 1st.
What?
I said not May 30th, July 1st.
July 1st. Yes. So July 1st was the Supreme Court makes a decision about the Trump versus USA case. About, yes, as Natalie was saying, it ended up ruling about immunity. So if we draw a timeline about the context of this case, so it all started with the US elections in 2020. So 2020 elections. And in the aftermath of the election, where Biden wins, Trump and his allies attempt to challenge the election with lawsuits, pressuring state officials, etc., and promoting claim of election fraud. Then we have, based on that, the January 6th riot on the Capitol. And in November 18 of 2022, so I'm gonna mark that here. The Attorney General, which is Merrick Garland, appoints a special counsel. Oh, did I say 2020? Yes, thank you, 2021. Appoints a special counsel to investigate Trump's role in the January 6th riot and the efforts to overturn the election. Not only on that, it was actually on two things. It was about the election, but also about the handling of classified information on part of Donald Trump. So they want to investigate those two things. And I believe this is right after, I have to confirm that, but I think, yeah, it would be important, but I recently realized that it was, I believe, 3 days, 3 days before the appointment of that special counsel is when Trump announced his intent to be a president candidate for the 2024 elections. So that's one thing. And then they appoint that counsel. By the way, so I'm gonna, because I would like for myself and for all of us to be familiar with the dynamics of how this works. So I mentioned that the DOJ appoints a special counsel. Does anyone know who the DOJ is, or like what the office is about? What does DOJ stand for?
Department of Justice.
Yeah. So the Department of Justice. And the head of the Department of Justice is the Attorney General. Which in this case, we said it was Merrick Garland. So the Department of Justice is an office within the executive branch, and the Attorney General, which is the head of that department, serves as the main lawyer, or it serves the president, the executive branch, in all legal matters. So in this case, it was the Department of Justice under Biden appointed a special counsel to investigate that. So moving on, August 1st of 2023, a federal grand jury, which I think was what Curtis was saying, indicts Trump on 4 counts relating to this investigation that the Attorney General was making. So the 4 counts were conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, which would be January 6th, obstruction of an attempt to obstruct an official proceeding, and then conspiracy against rights. And then 2 days afterwards, so here's the indictment. And then 2 days afterwards, in August 3, Trump pleads not guilty. So he's arraigned before the jury and he pleads not guilty to the charges. And because of that, there's a trial that is set to begin to see whether if he's guilty or not. And that was set to start March 4th, 2024. But why didn't it start? Does anyone know? So I'm gonna call this Trump versus USA. This is the actual trial that's called Trump versus USA. That's supposed to start in March. Why does it not start? So the reason it doesn't start is because Trump, as Natalie had mentioned, it's about the issue of immunity. So Trump is saying, hey, I can't be taken to trial because I was immune to what I did while I was in office. So that's one thing. And then July 1st, 2024 is where the Supreme Court makes a decision about whether Trump could claim immunity or not. So they make a decision about that case. So that's one thing. And later on, I'm gonna say here, August 2024, the special counsel files a superseding indictment, narrowing the allegations, but maintaining the same charges. So he's pushing on that. And then in November, when Trump is reelected, the special counsel moves to dismiss the federal charges because there's a DOJ policy. So dismiss. That sitting presidents cannot face criminal prosecution. That's a policy of the Department of Justice, the federal office within the executive office within the executive government. Yes. So in order to understand what so my focus is on this decision here. I want to understand what they're saying and what that decision was all about. So yes, the decision was about presidential immunity. And so in order to understand presidential immunity, I wanted to look at the history of that and how immunity works in general. So the concept of presidential immunity, we can trace the roots of it back to English common law. which established the principle of sovereign immunity. Which is sovereign immunity. Which is also known as the idea that a king can do no wrong, which is an idea less on the infallibility of the king, but more about the idea of preventing claims from disrupting the government. And so when the United States adopted the Republican form of government, the framers of the Constitution, I'm going to say in a way adapted that system of sovereign immunity, even though they don't mention it specifically or directly in the Constitution. They did adapt many of the principles of that by distributing the government in separate branches with mechanisms to ensure accountability as well. Yes, so that's one thing. It stems from sovereign immunity. And so sovereign immunity is not something that's only in the USA, like other countries. Most countries, I think, have that kind of legal framework. And it also, within the US, it doesn't only apply to the president. It also applies to other official officers. For example, the Congress has its own set of policies or rules that govern their immunity around their actions. Judges also enjoy immunity from legislative and judicial functions. And then the more that you go down the hierarchy in the government, people still have certain kind of immunity and more limited than at higher ranks. So for example, prosecutors, police officers, government employees typically have some form of immunity, some form of what's called qualified immunity, which relates to the functions that they are making. So they have immunity within a certain functions that they have. And yeah, that protection is supposed to allow the officials to perform duties without legal interference. So that's one thing. So just as an example about, for example, the Congress and what kind of immunity they have. This one does derive directly from the Constitution through Article 1, Section 6, which is called Speech or Debate Clause. Speech. It protects members of Congress from being questioned in court for legislative acts. So there was a case that upheld that immunity in, for example, Kilburn versus Thompson in 1881, which established the legislative acts, as I was saying, are fully protected, but it doesn't cover illegal activities unrelated to functions, like outside of the scope of their functions. Okay, so yeah. that's one example of another branch of government also having immunity for their offices, their acts. I want to read the chat. So Debbie says, Trump has been charged with hush money case, will be sentenced on 10th of January 2025, less than 2 weeks before he is set to be sworn in as president. Yeah, so the hush money case is a separate case that I think I also wanted to investigate, but it's a separate case. This one's dealing with the handling of classified information and the attempt to overthrow or to obstruct the election. Yeah. And then Trump slams judge in hush money from rejecting his immunity claim. So that's one thing. And then another thing that we need to understand about the decision by the Supreme Court is the concept of civil law and criminal law, because this case centers around criminal law and not civil law, because civil law, the immunities around that area had already been established, particularly in the Watergate era, in another court trial that Nixon faced. So does someone know what is the difference between civil law or a civil case versus a criminal case or the criminal law?
I'm not sure how good of a definition this is, but I think a criminal case is handled by the federal government, whereas your civil cases are you can't go to jail for them, essentially. And I can't remember who handles them. So like if you get a parking fine, that's a civil crime in inverted commas. Whereas if you kill someone, that would be criminal.
Yes, yes, that's right. So so criminal cases, yeah, they are handled by the government. So you can't like for example, if you receive some kind of offense within the criminal jurisdiction, it's not the person, the victim going against the offender. It's the federal government going against the offender, because it's considered an offense against society. So criminal law is the set of rules and principles that that address offenses against society, like for example assault or murder or theft, and yeah, that's pretty much. So I'm gonna do this. I'm gonna say like assault, murder, etc. So in this case, it's the government versus the aggressor or the offender. And the reason that the government is the one handling the case, or the prosecutor, is because it's considered a crime against the civil order, against the order of society. And the consequences are different as well, because as Curtis was saying, you can go to jail, or probation, etc. And also the standard of proof is different. So I'm going to say the penalty and the standard of proof. Is higher. So you have to demonstrate beyond a reasonable doubt that what you're saying is so, that the offense occurred. Whereas in a civil case, you have to demonstrate, what's the phrase, preponderant evidence. So you have to demonstrate that you have enough evidence, but it's not as high as beyond any doubt, as in it's required in the criminal case. And on the other hand, the civil cases, they handle disputes between individuals or entities on issues that are, for example, contract related or property related, personal injuries. And in that case, so I'm going to say civil matter is disputes between individuals. On things, as I was saying, like contracts or harm that's caused between a person and another person, but it's not within the category of criminal law. And the standard is lower, and the penalties are usually, you can't go to jail, as Curtis was saying. It's usually about paying a fine to the damaged party, etc. Oh, sorry, I didn't see the chat. Let me. So Natalie said, one's government punishment, one's individual, one's compensation. Yes, exactly. And Debbie says civil laws are filed by private parties, while criminal cases are usually filed by the government. Exactly. So not usually, they're always, you can't privately file a criminal case. So in a civil case, you can choose your lawyer, etc. In a criminal case, you just make I don't know in English the word, but you go to the police and they handle the case. And Blessing says a criminal case involves an action that is considered harmful to society, while a civil case is a dispute between individuals or organizations. Yes. Okay, so why is this important? Because the case that we are looking at, the immunity that this CODIS decided about was about criminal prosecution, and not civil prosecution. About civil prosecution, as I was saying, during the Watergate era, there was a clear Supreme Court decision that said that the president has absolute immunity from being prosecuted from civil cases. But no president had ever been convicted or tried for a criminal offense. Since this was the first time it was the court addressed that. So that's one thing. Oops, why? Okay. Anyways, so yeah, I just want to read a little bit of the court's decision about this case and see what we can start understanding from that. I just want to read the first 3 or 4 paragraphs. before I finish. So can I ask someone to read the first paragraph here? Anyone?
Okay. I can read. A federal grand jury indicted former President Donald J. Trump on 4 counts for conduct that occurred during his presidency following the November 2020 election. The indictment alleged that after losing that election, Trump conspired to overturn it by spreading knowingly false claims of election fraud to obstruct the collecting, counting, and certifying of the election results. Trump moved to dismiss the indictment based on presidential immunity, arguing that a president has absolute immunity from criminal prosecution for actions performed within the outer perimeter of his official responsibilities, and that the indictment's allegations fell within the core of his official duties. The district court denied Trump's motion to dismiss, holding that former presidents do not possess federal criminal immunity for any acts. The DC Circuit affirmed. The DC Circuit affirmed. Both the district court and the DC Circuit declined to decide whether the indictment conduct involved official acts. Should I read the other part?
No, that's fine. Thank you for 1 second. So I see Natalie saying, it says, what are official or non-official acts with regard to having or not having immunity? Is it to do with direct acts regarding to executive branch? Yes, so I also did look into that, and what refers to official duties, and it actually explains it a little bit on the court decision itself. But an official act is an act that's within the scope defined by the Constitution of the presidential power. So, for example, executing laws and executing pardons, anything that's related to his official capacity or their official capacity as president. And then there's going to be something that they're going to call so they call it the outer perimeter of his official responsibility. So they technically are drawing a perimeter, and it's saying there are things that fall here within this circle that are duties of that the president can do, but that also the things that only the president can do. So it's something they, just 1 sec, they call it gonna see, it has there's a technical name for it, but yeah, maybe we'll see it later. But basically it's saying that within the outer perimeter of the official duties, it's only things that the president can do. So it's his duties, but only the president can do them. But then there's other things that can happen outside. So the president is acting in their official capacities, but are things that are not exclusively related to the presidency, and it may overlap with someone else from the executive office or with Congress itself. So they are in their official capacity, but it's not a function that's exclusive of the president. So it starts overlapping. So it's not that clear whether it was within the inner perimeter or if it's in the outer perimeter. That's what they are referring to when they say that.
Sorry, Andres, just to clarify, you said when they say that, I missed something. When they say what?
Yeah, so this drawing that I did here, they are calling it outer perimeter of what is it that they call it, of their official duties.
So it's those things, the X's in red, which would be outside the scope, and so which wouldn't be covered by the immunity.
Yeah, so the things in red are outside of the outer perimeter for official duties. They are still official duties, but they're not exclusive to the president. So someone else could do them. For example, someone else in the executive branch, or someone else, or Congress. So let's say the president does something here. It could have been done by them, or it could have been done by somebody else. So if they're doing it, it's fine. It is within their capacity, but it's not exclusive. Whereas, for example, issuing pardons or that kind of things would fall, or deploying troops to another country would fall within this perimeter because it's exclusive of the president.
But the president still gets immunity with the outer perimeter.
Yeah, so what
Yeah.
they ruled is that within the outer perimeter, so within here, they have immunity, absolute immunity. And here they don't have absolute immunity, they have presumptive immunity. And what that means is that anything they do within this circle cannot be questioned, or it cannot be set, it cannot be examined, it cannot be taken to court at all, no matter what the motives were. But anything that's outside of that, the presumptive immunity means that if you want to take them to court for that, you can, but you have to show certain things. You have to meet certain characteristics. So, for example, you would have to say that taking the president to court is not. You have to show that it's not within this perimeter, and you have to prove that it's not affecting the ability of the president. Like the fact that you're taking them to court is not affecting the president's ability to function independently, and a few other things I think that you have to demonstrate. So you can, but it's much harder to take someone to court than if they didn't have presumptive immunity. I don't know if that makes sense. And then Natalie saying, like, asking Mike Pence to reject state electoral votes. I've not looked into that one. So I don't know the answer yet to that. But the thing with Mike Pence, I think it's a little harder as well, because when he's doing the January 6th thing, he is acting as a part of Congress. Yeah, it's not it's not fulfilling the executive role that he also has. So I'm not sure about that, but yeah, it's a good question. Does this thing about the perimeter makes sense, or is it clear? Maybe not fully. I do want to go through examples later. I think I'm going to do it in the Vesper study when it's my turn.
Are you saying then that that President Trump, because you're showing the degrees of what immunity means, right? So I think by by understanding that, I think Trump, I don't think he understands what immunity is. If you see what I mean. Even though you've explained what it is, I don't think he understands what immunity means. I think he feels like he can do anything and have immunity. That's what I think Trump thinks.
That might be the case. So in this case, for example, that we're dealing with. So Trump is saying, I have immunity for all my official acts. I think that's what he is saying. Now the discussion centers around what is within this outer perimeter of the official acts and what is not. And what the court is saying here in this decision is that it is the duty of the lower courts, because, so I think I forgot to mention that in the timeline, but before getting to the Supreme Court, this had to go through another federal court and then in the Court of Appeals, and they had decided that what Trump was saying is that he didn't have immunity, but they didn't say why Trump doesn't have immunity, because they didn't do the work of saying like, hey, this is official or is it not official act. So what the Supreme Court is saying is the lower courts have to determine whether or not this was within the outer perimeter or if it was outside of that perimeter. That's the first step that the courts should take. And is also saying if the court determines that it's within the outer perimeter, then it has immunity, and Trump was right. If it's outside, then it's a little bit more complicated. Blessing and Charity are saying, I think the fact that he pulled the immunity card means he understood what that meant, whether he wanted to use it for his own benefit or not. He has legal advisors who help him with that. Yeah, I think I see it that way too. So the concept of immunity is it wasn't a new thing at all. It's always been there in the US, as we were saying, not only in the presidential or the executive powers, but within all the federal government and Congress and the judicial branch as well. And yeah, it seems like Trump knew what he was saying. Whether or not he did have immunity for those acts specifically is part of the discussion that the court has to decide. Yeah, so that's one point. And the other point is that that I already made, is that all of this discussion is centered around criminal matters, because for civil matters, the court had already ruled that the president had the immunity for things within the outer perimeter, and I believe presumptive immunity as well within the outer perimeter. But I'm not sure about that. Maybe it was absolute immunity here as well. So with civil cases, it was already decided in 1980 something, I believe, in the context of the Watergate scandal.
Just to let you know, it's 11:45 here.
Okay, yeah. So I don't want to go forward now. What I want to do the next time is go through a little bit more of the decision that the Supreme Court gave, and I would like to analyze the opinions of the judges and the dissent of the other 3 judges. that dissented to that court's opinion, because in the context of our study, we're analyzing, or we're trying to analyze the discussions that are going on about the our different opinions around the matter, around us and the left wing. So Elder Parminder says, can you please share your thoughts on this SCOTUS decision, or is that for next time? So yeah, I can share my thoughts. So what I'm thinking is that the decision of the Supreme Court, what I can see is that it didn't change anything that was already there. That's what I can see more like historically. And then for the next time, but actually I don't have necessarily a settled position on that, is whether or not it's something that's how it should work, that the SCOTUS decision, that how immunity should work and shouldn't work. I think that's a little bit more complex. I think it makes sense that there is immunity. And yeah, I think in general, that's where my thoughts are. But that it didn't change anything, that's for sure. I can't go lower on the chat for some reason. I don't know if someone can read the latest messages for me. It's not allowing me to.
Natalie said, do you think the court, or asked the question, do you think the court gave full immunity?
So they did give full immunity within this circle of the outer perimeter, and then they didn't give full immunity within the official acts outside of the outer perimeter. And then so I'm going to say here, absolute immunity, presumptive immunity, and outside official acts is no immunity. I forgot to mention that. So there's like 3 zones, 1, 2, and 3. And no immunity is outside of the official capacity. So if it's outside of the official capacity, there's no immunity. Is there any other messages?
Yeah, Elder Pamenda says, so are you not sure if you agree with the SCOTUS decision?
Yeah, I think initially if I would have to answer that question, I would say yes. I'm not settled in that position, but I think I agree with SCOTUS decision. Yeah.
Can I just ask one more question? Well, it's not a question, it's I guess a request. You've got those 3 levels of immunity that you've put in blue. I think for me that's really helped clarify things. This progressive degree of immunity and the way you've explained it. I'm sure I'm guessing you won't be able to do it now, but when you do the study next time, if not all of the cases, because I can't remember exactly how many there are and how many are relevant to this SCOTUS decision, but I was wondering if you might be able to create a table for those lower court cases, not so much the decision, but the cases, and put them into these 3 categories. If I would call them, you've got absolute, presumptive, or no, like 1, 2, or 3. If you were able to put where each one would fit, so case 1, would that be in the absolute immunity ring, or would it be in one of the 2? I think I'd be interested to know because all the cases, I don't think they all fit in one of these, if I call them boxes. Some of them are different. Maybe some of them spill over between one or the other. I'd be interested to know where well, I guess where each case would be, or at least a few of them, so we could get an idea of how we would approach the subject, whether we actually agree that that case, say in Florida, whatever the case was, there may be two or three, that would be in the outer orbit where there is no immunity, and the right decision would have been that, or whatever that it would be. And another one, say the New York case, or one of them, would be in the absolute immunity, so he would have been unassailable. I don't know if you're able to do that, maybe for next time. I would appreciate that if it's possible.
Yeah, that would be really cool. So if I'm understanding you right, it's like grab the cases and say whether what decision they made about like if it was within 1, 2, or 3, and if we would agree with putting it actually in 1, if they put it there, or where would we put it?
Exactly, yeah. So not the outcome of the decision, but where we would place it and where we
would
believe
place it.
they placed it.
Yeah,
Thank you.
yeah.
Sorry,
Is it-
Andres. So,
yeah.
so with these cases, this immunity applies to both the civil and criminal cases?
No, so this decision applies only to criminal cases because there had already been a decision made on civil cases in 1980 something, around Nixon. It was a trial with Nixon, and the Supreme Court decided that for civil matters,
Okay.
yeah, they already had decided that the president does have absolute immunity within the circle number 1. I have to confirm what they said about circle number 2, if they do have for sure they said they have presumptive immunity at least, but maybe they did say absolute immunity. I don't remember, but it was
Okay, so what you're saying is whether it's a criminal case or no, you're saying the criminal cases. Actually, let me repeat my question because I don't know if you really answered my question.
okay.
Could I ask a question while Charity's formulating her one?
Mm-hmm.
You mentioned, I think 1980, that's the year that you said, where the issue of how the Supreme Court reviews civil action and comes to a decision. Is this the first time that SCOTUS has made a decision, or a case has come with respect to criminal law? Is this the first time they've made a decision on it? If 1980 was when they pontificated on civil matters.
To my understanding, about the president, yes, I think it's the first time they made an explicit decision, because there hadn't been any criminal prosecution to any president before. But that doesn't mean that the presidents didn't have immunity, criminal immunity. I think there was like a consensus that
Yeah, okay, so that makes it, but it's the first time SCOTUS has actually made this kind of formal decision, as they did with civil, which is why you've separated the two and say we don't have to worry about civil because it was dealt with whatever 40 years ago.
Yeah.
And now we're dealing with criminal issues because it's the first time it's been tested at the Supreme Court level, and that's the first time they've actually adjudicated and made a statement about how criminal cases against the executive branch, against the president, should be handled.
Yeah.
And I don't know if that's new to many of us. Thank you. Sorry, Charity.
No, it's okay. Actually, it clarified some of what I was asking. That so when we're looking at, like, for example, the cases that have been brought upon Trump, like Trump versus USA, is that a criminal case?
Trump versus
Or
USA was a criminal case. Yeah.
okay, so we are saying we are trying to I look at the criminal cases that are being leveled at the president and seeing if he's got immunity in what he was doing or not.
Yeah. Yeah.
Okay.
So,
Andres, I
mhm.
don't know the answer to this, but it's in relation to what I'll just when Nixon had his debacle with the US, I came up with it was Watergate and the tapes and etc. And SCOTUS eventually ruled.
You're
Hello,
breaking up for
can you hear me?
Yeah, you're breaking up a little bit for me. I'm not sure if it's me or
Yes,
if you-
Curtis, you're breaking, you're echoing a little bit.
Breaking up.
You, Andreas.
Okay, can you hear me okay now?
yeah.
Okay. I was asking if this is in relation to what Linda brought up. If
You're breaking up again.
oh no.
Mhm.
Okay, never mind.
It
I'll
seems to be better now. I don't know.
whenever I want to speak, it breaks up. Yeah, I was just asking if during the Watergate scandal, I think it was Watergate with Nixon versus the US, did SCOTUS not give a ruling with regards to that in eventually pushed Nixon to have to hand over the tapes? Wasn't that related in some shape or form? Again, I don't have the specific details, but I think it's been handled in the past, if not fully or extensively as this, but it might be.
Do you mean did the Supreme Court make him? Oh, yeah. I don't know. I don't know the answer for sure, but I do remember as well that in one case, I'm not sure if it's exactly that one or not, but the Supreme Court made a decision that presidents can be requested evidence of things even though they have immune, so they can ask the president, for example, I don't know for those if it was those tapes or not, it wouldn't be included there, but um I
Yeah,
don't remember.
I think he made the appeal that he had immunity or absolute immunity at least, and they rejected that and made him hand over. But I don't know if it's the same as this. So if that establishes precedent on some shape or form, or if they gave like as a holistic opinion as you've described now with this case.
So what I do know is that they concluded that for civil matters, which was the case at that time, it was a civil case, they do have immunity. So they did make those conclusions here in the Nixon case, but not about criminal because it wasn't a criminal case. If that makes sense.
He replied in the chat.
Oh.
Oh, you can't see. Sorry, I
Yeah.
just said thank you for clarifying. I thought it was
Oh.
criminal, but you clarified that it was civil.
Yeah, that one was civil. Okay, so I don't know if anyone has any other comment. I can't see the chat for some reason. It's not working, but
So Andres, sorry, in short, basically what we are saying is the question that's being brought to the court is whether a president can have presidential immunity in a criminal act or criminal case or whatever acts of criminality that can be seen as criminality as opposed to the civil one, because the civil one already has a ruling and decisions that are already there. Is that the question?
yeah, that is the question. So that's what the court was deciding about.
Okay, thank you.
Okay. So we can close with a word of prayer if you can join me. Dear God, we want to thank you for this Sabbath, that we were able to meet together to study your word. And we want to ask that you would help us to understand these issues and to understand the reasons why we approach them and how we do, so that we can learn more about you and about humanity. And I pray that you would also help us sift out all of the misconceptions that we might have, or distractions that we might have, or mistakes that we might make about these aspects that are very technical to us, so that we can look at them and correct it if we're making any mistake. We pray for all these things in the name of Jesus. Amen.